My name's Joel Fairbrother from Bow River Law. We're employment lawyers in Calgary, Alberta, and today I'm going to be answering the question, what are my restrictions if I leave my employer and start competing? Well, this comes up quite a bit, especially in Alberta. In Alberta is sort of the Wild West. Everybody likes to sue over competition, in many cases when there's nothing preventing it. Generally, employees are allowed to compete with their former employers. It does depend, though, on whether they've signed a non-competition agreement. And there's a difference between competing and soliciting. So we'll cover that in a second. But competing is just, are you able to, as an employee, are you allowed to work in the same field that your former employer worked in? And the answer usually is yes. Sometimes employees have signed a non-competition agreement or covenant with their employer. In some cases, those are enforceable. In many cases, they are not enforceable. And by enforceable, here's what I mean. So the wording of the clause or the agreement, it may be pretty clear that you're not allowed to work in the same field in the area where your employer worked for, say, 12 months or something, some other period. The wording might be clear, but courts really don't like these clauses because they're called a restraint of trade. They're something that prevents you from being able to earn a living. And for policy reasons, courts have always looked at these clauses with a dim view and have tried to ignore them or get around them if there's any way for them to get around them. So I guess the first thing I would say is if you're thinking about leaving your employer, or if you already have, and you're thinking about competing, or if you already are, if you haven't spoken to an employment lawyer yet, you should, because there are many ways that you can protect yourselves, and in some cases, there is no protection. Sometimes it's validly enforceable that you're not allowed to compete, but most of the time you are. Now, the difference between that and non-solicitation. So solicitation is a bit different. Solicitation is when you are, in general terms, you're reaching out or approaching your former clients and you're trying to get them to do business with you at your new employer or your new business. This is often allowed, but it's not always allowed. And it's more often, a non-solicitation clause would be more often enforceable than a non-competition clause. Because courts, while they generally want to protect employees, in many cases, employers do have a legitimate interest to protect, and they are, in many cases, quite vulnerable to their former employees. So even without a non-solicitation clause, though, or agreement, in some cases, former employees are not allowed to solicit their former clients. There are many examples of this, but the biggest ones would be if the employee is called a fiduciary, which is sort of top management, or if the employee is, in order to get that business, if they're using confidential information, which could include customer lists, it could include, in some cases, customer lists, it could include pricing lists from the former employer, contracts, agreements from jobs the employer has done with those clients, things like that. You can't use confidential information generally from your former employer. And so those are the general restrictions. But whether whether or not you're as an employee, to answer the question we started out with here, whether or not you're restricted from competing, the answer is usually not. Usually you're not, but there are exceptions. And if you're planning on doing it or you've already done it, there's no question you should speak to an employment lawyer first. I hope this has been helpful. Again, this is Joel Fairbrother from Bow River Law. I'm an employment lawyer here in Calgary, Alberta.